Welcome back, everyone. As you probably guessed from the title of the video, as well as the thumbnail, we're talking about the Rahimi case. I have some notes here just to kind of keep me on track. The ruling came out today as of when I'm recording this, and it is a long ruling. It's 109 pages, which is not normal for the Supreme Court. And I think the reason for that, or rather, I think there is a reason for that, I should say. The ruling itself was 8-1 with the only justice in the dissent being Clarence Thomas. We're going to get into his dissent today because I think it's important. We are also just going to kind of go over a few of the highlights that the majority ruled in the case against Mr. Rahimi. So before we get into all that, I just kind of want to give an overview of what this case is and sort of what it will impact going forward, because there are some things that it will impact going forward, which is why I think it's 109 pages long. I think they wanted to set the justices, I should say, wanted to set some things up that are in the queue for review by the Supreme Court. So basically what this case is a case of a really bad guy, Mr. Rahimi, legitimately a terrible human being by all accounts, like even his attorneys say so. The man is in jail right now. Long story short, he threatened violence, may have committed some violence depending on where you actually read it, had some issues with firearms being used against his ex-girlfriend. There was a restraining order. And the restraining order was challenged, essentially saying that his Second Amendment rights were taken from him without due process. That's the macro overview of this case. The problem with this case is there's an old adage, and if you follow me on social media, I posted this earlier today, that hard cases make bad law, meaning that it's a hard case because human emotions get in the way, right? And I think a lot of the Supreme Court justices fell victim to this, particularly Justice Alito in this case. Whereas a lot of people, Supreme Court justices included, look at this case and realize this is a bad person. Mr. Rahimi is not the person that we want to set the legal example for, and it's very easy to rule against someone like this, someone who is a criminal, someone who has done things that we frown upon as a society. And in that type of case, it's very easy to make bad law. And I think in this case, that is what happened. I think this is bad law. And I think Justice Thomas is correct on this one. If you guys watched my video on this case from a year or two ago as it was going through the appellate process, I thought that this case would be a 2-7 loss. And I thought Justice Alito would rule with Justice Thomas on this one. He did not. I guess with that, we'll get into it. Before we get into all that, a couple things we need to knock out here before we get into the actual reading of the ruling itself. Number one, we need to thank our channel sponsor, of course. The main one, and that is going to be Brownells. We don't have any cool guns, ammo, optics, etc., anything like that to show you today. However, Brownells does have all of that, so definitely check them out if you guys are interested in any of that, as well as gunsmithing supplies. Brownells is the place to check out for that. Additionally, this is going to be a Mug Club episode, meaning that we are going to do the episode here breaking down this case for free on Rumble as well as on YouTube. And then after that, we're going to head over and talk about the pistol brace ruling, because that unfortunately has just been challenged and is going to go a certain way over the next year or so. And we are going to talk about that exclusively on Mug Club, where we can say whatever we want and don't have to worry about free speech being infringed upon like it is on YouTube and many other places. If you guys are interested in checking out that platform, it's not just me, it's myself, Steven Crowder, Alex Jones, Nick DiPaolo, Brian Callen, the Hodge twins, and probably someone I'm forgetting, making exclusive member content over there. There should be a code here on your screen for a free month if you guys are interested in it, rather, at the website here on your screen. And with that, let's get into the actual ruling. Again, this thing is 109 pages long. I will link to it down below in the video description. I'm just going to highlight a few overarching themes to let you guys know where the actual justice is that made this ruling. Again, it was authored by Justice Roberts. And basically, right in the beginning, he says that, in particular, the order, i.e. a restraining order, must either contain a finding that the defendant represents a credible threat to the physical safety of his intimate partner or his partner's child. It goes on there. So what they're establishing there is a credible threat, not just someone believes that someone might be a threat. That's going to be important as we get to future cases as we go on, but let's continue. Before we get into the reasons that Justice Roberts cites here for this ruling, we need to understand the Bruin decision. So most of you guys who are watching this video actually are not subscribed to the channel, so you may or may not know, but in 2022, the Bruin decision came out from the Supreme Court, and what that established was that Big picture is that for any law to be constitutionally valid when it comes to the Second Amendment, it has to be based in the text, history, and tradition of the Second Amendment as it was adopted in 1791. So what Justice Roberts, as well as the other justices here, point to is two different sets of law, surety laws, which we'll talk about here in a second, as well as going armed laws. And what those were a couple different standards, legal standards that were in place in the colonies when the United States was founded, as well as, in the case of surety laws, British common law that was imported into the United States when we became a country. So to that end, the going armed laws, a particular subset of the ancient common law prohibition on affrays or fighting in public, provided a mechanism for punishing those who had menaced others with firearms. And again, go back to the earlier point of a credible threat. We also have to establish here that they have also menaced others with firearms. Surety laws could be invoked to prevent all forms of violence, including spousal abuse, and also targeted misuse of firearms. These laws often offered the accused significant procedural protections. So those two standards are what the Supreme Court here is arguing provides the basis for someone having a restraining order, being stripped of their firearms if, again, there is an actual threat or a real threat or a perceived threat of violence going forward by that individual. So it can't just be that they had a speeding ticket, for example. There has to be the actual real threat of violence based on these two standards. And to that end, Mr. Rahimi's defense said that essentially there was no actual historical analog, despite the two that the Supreme Court is arguing here. And the Supreme Court's ruling here states that the Fifth Circuit, which is where this was appealed, erred in the reading of Bruin to require a historical twin rather than a historical analog. The panel also misapplied the court's precedents when evaluating Rahimi's facial challenge. Rather than consider the circumstances in which Section 922, Section 8, which is the law that we are talking about here regarding restraining orders, was most likely to be constitutional, the panel instead focused on hypothetical scenarios where the provision might raise constitutional concerns. And if you guys are searching social media right now or other YouTube channels, this really is the thing that most people who are purists in terms of the Constitution are attacking right now. A lot of folks think that the justices here made a stretch from the Bruin decision here, saying that you don't need a historical twin, when in fact in the Bruin decision it kind of says you need a historical twin, and they're saying you can have an analog instead with those surety laws as well as the going armed laws. And I will let you guys debate that down below in the comment section, but overall, you guys have an idea now of what the Supreme Court is saying here was the reason that someone could be stripped of their Second Amendment rights if they just have a restraining order against them, even without due process, because a typical restraining order is just someone, typically a woman, a wife, a girlfriend, whatever, going to a judge and saying, I'm in fear, or depending on where you live, it could just be the sheriff and saying, I'm in fear, have a restraining order on this person, deprive them of their Second Amendment rights. They are saying here that as long as they are a credible threat, then that is enough due process, i.e. the court is somewhat involved to deprive that person of their right to defend themselves with a firearm. Now, we'll get into Justice Thomas's decision on that, which he disagrees with, and I tend to agree with. Before we get into Justice Thomas's decision, again, this will be linked down below if you guys want to look into it. Justice Thomas's ruling or dissent starts on page 72. In my opinion, for anyone who wants to understand the Second Amendment as it should be interpreted, it's required reading. It's not that long. Again, link down below, starts on page 72, but he starts out with a banger that is absolutely true. And he says, after New York State versus Pistol Association v. Bruin, this court's directive was clear. A firearm regulation that falls within the Second Amendment's plain text is unconstitutional unless it is consistent with the nation's historical tradition of firearm regulation. Not a single historical regulation justifies the statute at issue. Therefore, I respectfully dissent. Boom. He is 100% right. I absolutely agree with him on that. Again, in my opinion, the other 8 justices are stretching here for those 2 analogs that they say apply here, which in my opinion, they absolutely do not. I'm going to read one more really clear point here from Justice Thomas's dissent. Then I'm going to get into sort of a general discussion and what I think will happen going forward. He states, in addition, Section 922, Section 8 strips an individual of his ability to possess firearms and ammunition without any due process. I 100% agree with that. Rather, the ban is automatic, uncontestable consequence of certain orders. Exactly. So what he's saying is as soon as this order happens, the consequence is that you can be stripped of your right to own firearms as well as ammunition, which is a violation of the Second Amendment. I agree with Justice Thomas. Again, I think the reason the other justices went with this is Mr. Rahimi is a terrible person, and it's very difficult to rule in favor of someone like that. It's just a bad case, makes bad law, and that is where I think we are. And with that, I think we have enough reading from the decision for one day. A couple things kind of to talk about here before we close the video out. It's just restraining orders in general. Obviously, which the general case is, usually these restraining orders are put in for or requested by women who are in fear of violence or great bodily harm by men, typically someone they're in a relationship with, the father of their children, etc. And in no way do I want those women to be hurt by a ruling like this going the other way. That said, this ruling itself basically keeps everything where it has been, i.e. the status quo over the last 20 years or so remains in place. So nothing really changes with the ruling, but it does, again, allow the state in this particular instance to infringe on someone's rights if, let's say, a woman lies about something. Very quickly, sometimes these restraining orders can go into effect within a matter of hours. And in that case, think about it. The police are knocking on your door. You may not know why, and they're there to take your firearms because someone has taken out a restraining order against you. It just puts Americans potentially in a very bad place where things can go wrong very quickly. Again, conversely, though, I don't want people who are living in fear of someone who is legitimately evil and legitimately a threat to them, potentially coming to do them harm. The answer, in my opinion, is to give them due process rights and let them go through the legal process before any rights are deprived from them. That said, again, this case doesn't change anything in where we are in America right now, so it's not all that detrimental. However, I think a case that we've talked about here in the past, which very likely is coming up for Supreme Court review, will in fact be impacted by this ruling because, of course, every Supreme Court ruling sets a precedent. One thing in a negative way that this precedent does, in my opinion, is it dilutes the Bruin decision a little bit. It makes it a little bit less clear, as Justice Thomas pointed out in his dissent. That is not good. The other thing, though, that it could be good for is folks who are non-violent felons, as well as folks who use drugs that could make you a disqualified person. So, for example, U.S. versus Daniels is a case that is pending before the court, and essentially, long story short, in that case, the person, Mr. Daniels, was a marijuana user and was denied his right to keep and bear arms. I think if you look at the language here where it talks about credible threat, credible harm to others, rather than just a general nuisance, as they talked about here in this case, it does set the standard where Mr. Daniels or, for example, Hunter Biden could get their rights back or rights restored under this new standard because, again, they were very clear. If you actually read the ruling over and over and over again, they say credible threat, real threat, etc. They hammer that one home. And if you look at, again, someone who is a marijuana user or someone who, for example, got any type of, for example, President Trump, who has been convicted of a felony because of an accounting error, those types of people under this new standard would not be prohibited from exercising their Second Amendment rights. So I suppose it's bad news and good news. Let me know what you guys think down below in the comment section. I definitely look forward to hearing from it because it is a complex case. And again, it is a bad case making bad law. That is my take on it. But there is some good news potentially going forward based on what was written here. So with that, guys, that's all I have for you. If you guys haven't been following me on all my various social media pages, I recommend you do that because that is where we break these stories first, always, because it's easier to get a post up than it is to get a fully edited video. Additionally, if you guys aren't subscribed, as the majority of you are not based on statistics, hit the subscribe button. If you've done that and you've hit the notification bell, you can also sign up for my email list if you're not seeing 2 to 4 videos a week here on the channel, because most of you guys who are subscribed have hit the notification bell. Tell me that you don't see them and you're not getting notified. So very easily you can sign up for the email at the website here on your screen. This email goes out once a month and it has all the videos since the previous month's email went out. So that way there's no big tech giant censoring your eyes from my content. Additionally, we have daily deals email. If you guys like the things we talked about being prohibited in this video, whether it be guns, ammunition, lights, lasers, optics, etc. All of those things are in our daily deals email. You can sign up for that. It's completely free. It has 8 of the best deals that we find around the internet on those types of items. If the item, whatever it is in the email on that particular day, it's the cheapest I know of anywhere on the internet. So that way I've done the price comparisons for you. So that way it saves you guys some time because I've done the looking and hopefully saves you some money as well. There's also a good meme in there that a lot of folks like. So if you like Second Amendment memes, you can subscribe to that email as well. And with that, that's all I have for you. I look forward to seeing everybody over on Mug Club.